Hey guys, let's take a look at some of the breaking developments in the Jane Doe versus Manson case in New York, and also just generally a little bit of a closer look at the case overall. So first today, Valentine's Day, happy Valentine's Day from Howard King to the plaintiff's team, as King shows that he's perfectly capable of fighting a war on two fronts in California and also on the East Coast in New York. As we talked about earlier, he removed the case to federal court. Whether it stays there or not, it's a different issue. That was already discussed, but he didn't let that file get any dust on it, because today he sent the court a letter, requesting a pre-motion conference for a motion to compel the plaintiff to file the complaint with her actual identity. And here's some of the letter. King notes that the presumption is that you will disclose yourself. That's how lawsuits are supposed to proceed. And if you don't want to, it's up for you to meet the burden of why you shouldn't be doing that and why you should be allowed to be anonymous. King goes on to cite some authority to, hey, look, Warner intends to move to compel this because her identity has not been kept confidential thus far. And when it's already been public, courts have found that, and including apparently, he says here, in some of the New York federal courts, that you should not be allowed to have an anonymous filing if your name is already out there. And in her own complaint, she notes that after other women came forward online, she did as well. She came forward online as well. And of course, I think we all know who is being talked about in this case, right? So it's not any kind of mystery. And that's basically what he's saying. He's saying that the plaintiff voluntarily and publicly disseminated information, including on-the-record press interviews, social media postings, podcasts, and other communications that identified her and her accusations against Warner. And then he says, unsurprisingly, those things contradict the allegations in her anonymous complaint in many material respects, which bears on her credibility and exposes what he says is the illegitimacy of her otherwise time-barred claims. And she can't now be allowed to avoid public scrutiny of her accusations by hiding behind anonymity. So that's a good argument. Look at the steaming footnote here on number 1. Nor should counsel be permitted, as they have in recent days, under the cover of their anonymous complaint, to peddle abject falsehoods about Manson via their endless torrent of press conferences and social media posts. So he's hitting back at this meme machine that's been out there. And he also notes, look, we got to do this because this is a potentially case dispositive issue. She says, I think in her declaration, that if she were forced to publicize her identity as part of filing the lawsuit, she would reconsider doing it and proceeding with it. So is she saying she'll be a Smith line and give up if her name comes out? It's kind of strange, since I think everybody knows her name was out there, but that's what she did say. So Manson's got a point here. Also, he points out that, look, if she stays confidential, that affects how he can answer the lawsuit, what he can attach as exhibits, what has to be under seal, and all of that sort of thing. So it is an important issue, whichever way the court were to go on it. And he asked the court to stay his responsive deadline and give them time to brief this thing up if they're going to do this motion to compel. So no response from the plaintiff yet. I don't even think her lawyers have come in formally on this case yet at the federal level. So this is... they're going to have to deal with it, though. King is not letting this thing sit around, and it's the right thing to do. If he wants to rebut this anonymous filing based on these things, it's good to go on and throw it on out there. So you probably already know, of course, the core of this case are the assault allegations that the plaintiff says occurred when she was 16, a minor, and 19. And second to that is the alleged responsibility of Interscope. I'm not going to talk about Nothing Records, since in the complaint they even refer to that in the past tense, for Interscope's alleged negligence, just generally in handling and being around Manson, and also for retaining and supervising him, how they did that. And then third tier, maybe they have a general cause of action against all the defendants for deceptive advertising, deceptive conduct and stuff. But of course, the core of it is the assault, right? Otherwise, there wouldn't be a lawsuit. So I'm going to hit a couple questions, but also talk about maybe the merits of this thing and some of the points King brings out. Why a civil suit instead of letting the state prosecute? I've seen some comments about that. This should just be a criminal action. That's a fair point. And if you're a detractor against these claims, you're going to say, well, they're using a burden of litigation to extract money in a civil suit, even if nothing happened. You can't do that so easily in a criminal context because you got to convince the government. Yeah, okay, that can happen. It does happen. But also sometimes the state just won't prosecute even if a wrong was done. And if they do, restitution in a criminal case that's granted to a victim can be far short of the full scope of damages that's recognized in a civil case. A civil case also gives you options for additional responsible defendants, like bringing in Interscope here. The state could also agree with you that, hey, you got good evidence, but we don't think it's beyond reasonable doubt evidence. But if you go to civil court, of course, your burden of proof is just usually more likely than not. So a much lower burden of proof. So those are some reasons why it's legitimate to bring a civil claim instead of a criminal claim. And sometimes, of course, people try to pursue both. I'm not saying which is the right answer here. I'm just answering that question generally. As to this suit being brought so long after the alleged acts, well, the new law is making all that possible and getting everybody's interest up for doing that. And whether you think it's good or bad probably depends on the case, maybe. Anyway, because this case involves assault on a minor, I think and have thought that it's the most serious allegation against Manson yet that he's facing in court. But this aspect of the lawsuit is subject to some serious questions in terms of proof. And King alludes to it in his letter, but people have already talked about it online. Of course, Colonel Kurtz hit it in great detail in her 4-part series. But even if you're not generally pro-Manson as she is, if you're on the anti-Manson side, you have to look at these prior inconsistent statements and see there's probably an issue there. So for this case, Manson says, look, this didn't happen. So now you're at she said, he said. But second, and way more damaging, the plaintiff has said that it didn't happen. At least she said that before she filed the suit in podcast and newspaper articles. While she described her past encounter with Marilyn Manson when she was 16 pre-lawsuit as far short of forced copulation, basically forced kiss is what she has said, she now does claim that in the suit. She claims forced copulation in the suit. In the past, she's described complimenting Manson on his hair, was informed that he used Pantene, and then she says he tried to kiss her non-consensually or did do that, she says. She has said she then got off the bus, but she has also stated, at least to a newspaper, and I don't know about the podcast, maybe the same, that he was, quote, never violent, end quote, to her. And now the lawsuit has changed to say, hey, there was forced sex and pain involved. So those are certainly at odds. So now Manson has as a defense not only his own declaration that he didn't do it, but also her own prior statements that at worst, this was some kind of, his attempt to kiss her, or he did kiss her and he shouldn't have, which I'm not saying is right, but that's way different than what is in the lawsuit, which is a forced full-on sexual acts. And remember, she has the burden of proof. But wait, isn't all that stuff hearsay, what she's saying in the podcast and the newspaper and everything? Generally, no, as statements made by a party going to be used against them is an admission by a party opponent. And it's excluded from the definition of hearsay, even though logically it still is. But now, to use those against the party opponent, you still have to show those statements are authentic. That ought to be easy to do with a recorded podcast and probably pretty easy with a newspaper, but then it brings us to a third intriguing piece of potential evidence, the email. Marilyn Manson uncanceled that account, was sent an email that is allegedly from the plaintiff, pre-lawsuit, that would further undermine her case. Check out the account to see it if you haven't. The account sets out how that email was obtained, since people said, hey, you probably made that up yourself or somebody else did. So the account holder says, look, this is how I got it. This is my analysis of it and why I believe it's authentic. And in my opinion, that is definitely a good faith, honest description of the account holder's opinion and basis. And I can understand it if you're convinced by it. But my caution is just this: maintain skepticism. Remember the alleged incriminating recording of Manson? Did we ever find out if that was real or not? Many were skeptical of it. How about that FBI letter? Maybe we all should have a big box of dubious documents that you just need to wait on to see whether it's real or fake. Some of them certainly come out as fake and some of them come out as real. So I'm not saying Marilyn Manson uncanceled is wrong here. I am saying that you would have to authenticate that email to use it against her. And so the question is, can they use it in the case, or will it show up in the case? And the answer is, yeah, it could happen. But you got to show it's authentic, and that's a process that's down the line from here. Now, I'm not going to say it doesn't show up in some kind of motion early on. Remember, we got the Smith line, leaked DMs, and double hearsay issues in the Wood-Gore case and all that. But I am saying for it to be real evidence, or even an admission by the party opponent, you need to authenticate that email. And there are ways to do it through discovery. There are also ways in discovery for it to be shown to not be authentic. So we'll just have to wait and see on that. But I understand where the Marilyn Manson uncanceled account comes from. And I like it when the analysis of the person thought that. And you can agree or disagree at this stage. And then if it's important in the lawsuit, well, certainly Howard King knows how to get it established as authentic if it is. So that wouldn't be an issue if it is real. Probably. So back to the case, we're faced with a lawsuit involving allegations of forced sex on a minor. versus pre-lawsuit statements that are inconsistent with that. And this is critical not only for the allegations involving acts with the minor, but also because the plaintiff uses these allegations of what happened when she was 16 to link to what she did when she was 19, saying that she had not recovered from the previous assaults, and so she was susceptible to being lured into Manson's dark world. We know from her lawsuit that she's saying that, hey, when Manson came to LA, where she was living at the time, she went and watched his show. Then she flew to Texas to watch his show. Then she traveled to New Orleans to watch his show. And then she traveled around with the band for a month. And in the course of this, she says there was lots of sex involved. And according to her, it wasn't a good situation. But yet she was putting herself in that situation. So how is she going to show that it was non-consensual when she kept showing up for it? Well, she's saying, look, I was lured into it. I had been groomed over this period of time. But again, all this starts when she's 16. And if her story has changed so much from what she told only a year or two ago to now, you have to wonder whether she's going to be able to prove that with her own statements. What else has she got? Because her statements being so inconsistent, I think, are a big roadblock in this case. Let's put it this way. Is it more likely that she would leave what she was doing in LA and go follow this band around the whole nation if, as the suit says, she was violently attacked at 16 and left, in such bad shape, or if she had an encounter with an admired musician and star that she couldn't decide is this good or bad, which is what she had said before the lawsuit was filed? I think the logical conclusion is the second one, and that just puts the giant hole in the case as to the level of assault alleged. Now, you could say, hey, he still could have groomed her with lower level conduct, and while that's true, it's not what she alleged in the suit. I suppose the plaintiff's side could, or maybe will, say that she minimized the story before she filed the suit because she was ashamed or something like that. She didn't want to own up to just how bad it was. And they may do that. I mean, that could be true, right? Hypothetically, whether it is or not, I don't know. But if you're doing that, you're working from behind the eight ball because you told a completely, largely different story before you filed the suit to when now you're filing the suit and you're looking for money. Because that's what the suit is for. It's for money from Manson and Interscope. That's the point of filing the suit. So if she's not credible for her allegations of what happened when she was 16, and there's a good case, there's a credibility problem there, as Manson's attorney says, why would you put any higher level of confidence on her allegations of what happened when she was 19, when clearly she wasn't kidnapped? She voluntarily went with this band and then says bad things happened to her that she didn't consent to, and certainly that could have happened. But the point is, this is a case where she has to prove it. And what is the evidence of that? It's a big problem, but it's a long way from the start of a suit to when a suit ends, and many twists and turns are possible. Something could come up, and this then analysis we've had to do on other cases, and that is a well-heeled defendant independent of Manson. A lot of the allegations in the suit certainly are there to make Manson look bad, but they're also there to show notice by Interscope of the danger that the plaintiff says Manson posed. They're looking to show, aside from the assaults, that Interscope was aware of and didn't care that Manson was likely to engage in assaults, and turned not only a blind eye toward that, but also helped create the environment where these young fans could be victimized by a predator. That's her allegation. Now, there's a lot of hurdles to that kind of claim legally, but you get the logic of it, right? And I think that's really where they're headed. So despite the memes that target Manson and that sort of thing, specifically, you have to think, in my opinion, that Interscope is the fish they like to reel in here, right? That's a big pocket, deep pocket. So studios, record labels, promoters and stuff are exposed, at least to some degree, in these type of suits. No doubt it's good if such organizations are induced to consider the safety of vulnerable people, along with good times and the bottom line. But no doubt, too, they're tasty targets for the plaintiff's bar, and they may face suits with little merit, particularly now that very old claims can surface from decades ago, putting them in the spot of defending the actions of executives and managers who are likely are long gone, maybe sometimes long dead. So it remains to be seen if Interscope's defense strategy will align entirely with Manson, or as time moves on, if they develop different ideas on how to dispose of the suit against them. At any rate, Manson's attorneys have gone on the offensive. They've removed the case to federal court, and before anything really else could happen, as soon as their pro hac vice motions were granted, which was done at the end of last week, they filed this letter to the court for a pre-motion conference saying, we are going to challenge the plaintiff's ability to be anonymous in this case. She's known everywhere else, And she's using this as a tactical advantage and doesn't deserve the protection of the court in this way. So it's a good fight to have going on to start with before anything else really is going on. Now, this will bog down probably at some point and may even be thrown back to state court. I don't know. But no matter what happens with it, you're going to end up with the motions and the delays and things like that. But out of the gate, Manson is showing a strong defense here, which is good for his team to do that because they've had serious litigation to contend with out in California, and to be so quickly responsive to the one in New York, I think, shows that he's got a team that's working hard for him. And while I have said that I think this is the most serious allegation against him, based on the evidence that's out there, it also looks like he has a very solid defense to show that the plaintiff won't be able to prove her case here. So whatever happened or not is a different thing than what you can prove. And of course, it may not have happened, but can she even really prove it if it did happen with all these inconsistent statements out there? She's going to have something, I think. And I don't know that exists or not. So that's what's happening for now. There'll probably be some more developments on this soon because the plaintiff's lawyers are going to likely appear in this case at some point soon and have something to say, I would think. They're not exactly quiet on social media, so you would expect to hear from them in court as well. And we'll see what happens. Thanks, bye.